this is Heather Stone, Executive Editor of New York Apartment Law Insider. I'm here today with Eileen O'Toole, New York attorney and the author of the New York Rent Regulation Checklist. Today we're going to talk about the new rent law that was passed back in June. And I know our readers have had a lot of questions about what's in the law, and your clients have had a lot of questions. So first, Eileen, could you just recap what are the main highlights of the law?
Sure, Heather, thanks. In connection with rent stabilization and rent control, the law significantly and substantially changes these laws more than anything has been changed in quite a long time. One thing that has happened is that vacancy deregulation and high rent, high income deregulation are abolished, at least going forward since June 14th when the law went into effect. The law specifically says that apartments that were deregulated before June 14th remain deregulated. So that's a big change. There are substantial changes to how rent overcharge complaints are processed. The length of time that DHCR or a court will look back and impose liability has been increased from 4 years to 6 years. The treble damage penalty, 3 times the overcharge, has been increased. The period of time for that has been increased. And the changes about the rent overcharge laws are being applied to pending complaints. So anything that's already been sitting with DHCR or before a court is subject to the changes in the law. There are also significant changes to the permissible rent increases for individual apartment improvements and major capital improvements. These used to be permanent rent increases, now they're temporary rent increases, and they're subject to a time limit, and they are subject to more scrutiny and more limitations as to the amounts.
So all these changes are effective immediately?
For the most part, yes. There's a few variations on a few things that we can talk about as we get more into some of these topics.
So how do the changes affect luxury deregulation?
Okay. There's 2 types of deregulation under rent stabilization and rent control. You have vacancy deregulation. If an apartment becomes vacant and the rent was over whatever the deregulation threshold was that year, an apartment could become deregulated. Now there is no more vacancy deregulation. If an apartment was vacancy deregulated before June 14th, it remains vacancy deregulated. Going forward, there's no vacancy deregulation. For high rent, high income deregulation, there are some questions because the law is effective June 14th, but the high rent, high income deregulation has been subject to an annual filing period, and it's been going on since the 90s. So if an owner filed an application in 2016 because the tenant's rent had gone over the threshold, and the DHCR then would confirm with the State Department of Taxation and Finance whether the income was over the threshold, there could be a finding that the apartment was deregulated. DHCR has applications sitting, in some cases, going back at least as far as 2016. So the question is what becomes of those applications. They're still pending. The filing period for 2019 ended on June 30th, 2019. So by the time the law changed, a lot of people had already filed their applications. So the law says that if an apartment was lawfully deregulated before June 14th, it remains deregulated. But if the DHCR hasn't ruled on these applications, and there's no ruling that it's luxury deregulated, there's a question about whether those apartments are lawfully deregulated. On the tenant side of things, tenant attorneys or tenants would be saying, well, these were pending, there's no ruling, these apartments are not deregulated. From the owner's standpoint, there may be some question about whether they're lawfully deregulated and what's going to happen. So far, I haven't seen DHCR issue any notifications or notices to to our office or to owners we know who have filed these applications as to what they're doing with them.
How do changes affect vacancy and renewal leases under rent stabilization?
Okay. There's some big changes here also. Vacancy rent increases have been abolished. They're under the rent stabilization law. For quite some time now, there was a 20% vacancy allowance if new tenants got a 2-year lease. If new tenants got a 1-year lease, the amount changed from year to year, but it was generally somewhere in between 16 and 19%. Now there is no vacancy increase. And there is also part of the law says that the Rent Guidelines Board can't set vacancy increases either. Before they put it into the law that you had the 20% statutory increase, the Rent Guidelines Board used to set vacancy increases every year. So the question that has come up is that if now for a vacancy lease for a new tenant, you can't charge a vacancy increase, can you charge the renewal increase that would apply to renewal leases? And most of the attorneys I've spoken with or heard speak about this believe that there now is no vacancy increase and that you cannot collect the renewal increase for vacancy leases. Some people may question that, and we haven't heard anything from the legislature or from DHCR giving any guidance on what specifically the law means on this front. As for renewal leases, there are some things that may be changed in terms of what you do about preferential rents, which we may talk about. But the renewal leases aren't changed so much under the law. It remains to be seen whether DHCR will or how quickly they will revise the forms, because DHCR publishes the renewal lease form that's used for rent stabilized tenants.
Okay, well, speaking of preferential rents, we had a question from someone who asked if owners now have to renew a tenant's preferential rent rider using Rent Guidelines Board's renewal guidelines over the last prior preferential rent, how does this affect how renewal leases are offered?
Okay, this question has come up a lot. I've heard it several times over the last 2 weeks. I was actually a little surprised about how much questions there were about this. Preferential rents have been around for a while. You have, under rent stabilization, you have a legal regulated rent that is increased whenever you have a vacancy or when you had a vacancy or a renewal increase. In a lot of instances, if the market didn't bear the legal rent, owners would charge tenants a preferential rent. And generally this was done through a lease rider, so that the lease always said, this is the legal rent, this is the preferential rent. And the law was back and forth about this, but for a while now, you could have a preferential rent rider that said, your legal rent is $1,500. Under this lease renewal term, I'm going to charge you $1,200, but it's only for this term. The next time your lease is renewed, we can jump back to using the $1,500 as the base rent. Now, under the amended law, you can't do that. If you give the tenant a preferential rent, you have to renew the tenant's lease under the guidelines, but above the preferential rent. What I think is confusing people is that I'm not sure if owners are aware that you should still keep track of both. And this has been an issue for owners in the past. If there was no real record that you had both a higher rent and a preferential rent, you could lose the right to collect the higher rent. But both in the renewal leases as they're set up now and as they may be modified, I don't know, and under rent registration, you put down both the legal rent and the preferential rent. So owners should continue to do that so that at the point where a tenant moves out who had the preferential rent, it will be clear what the legal rent was and that you can resume charging the next tenant the legal rent rather than a preferential rent.
So what happens if a rent-stabilized tenant dies or moves out and there's a family member successor tenant? What happens in a preferential rent situation?
That may be a question right now. Well, as the law has stood for a while, a successor tenant isn't a family member who's entitled to remain in the apartment and become a tenant when the rent-stabilized tenant either dies or moves out. That individual is entitled to a renewal lease. So if that successor tenant is entitled to a renewal lease, it seems that they would also be entitled to the preferential rent. Now, that may not be 100% clear, and that may be an issue that may be subject to some difference of opinion and may come up in DHCR complaints or in case law. But it'll probably take a while for that to happen.
Okay, what are the key changes to amended laws concerning rent overcharge complaints?
Okay, there are a lot of changes concerning rent overcharge complaints. The first thing is that instead of having what has been called the 4-year rule or the 4-year look-back period or the 4-year statute of limitations, it's now been increased to 6 years. And what that means is that if a tenant filed a complaint with DHCR today or raised a claim in a court proceeding today that they have been rent overcharged, the DHCR looks at first what is the base date rent for looking at this complaint. So if it's August 2019, 6 years back is August 2013. If it was 4 years, it would be August 2015. So going back another 2 years allows for more review of, you're not looking at what was the rent 4 years ago and has it been legally increased. You're looking at what was the rent 6 years ago and has it been legally increased. So that's a big change. And in addition, there's a lot of language in the new law saying that if the DHCR or a court needs to look at information that goes back more than 6 years to figure out what really should be the legal rent, they can do that. So in effect, there is no limitation on how far you can look back. There's a limitation if there is an overcharge, the overcharge and the refund can't go back more than 6 years. But the DHCR or a court may seek information going back more than that period of time to determine if there is an overcharge.
And they can do this to pending complaints as well as newly filed complaints?
Yeah, that will probably be a point that will raise a lot of objections, and it remains to be seen where they'll go. One of the things that both tenants and owners have been concerned about for a while now is that DHCR has been backlogged to the point where there have been a lot of rent overcharge complaints filed in the last few years. And I know in my office, for example, there are complaints that we have answered on behalf of owners a year ago, a year and a half ago, 2 years ago even, and there has been no ruling by DHCR on these complaints. So when the complaints were answered a while ago, the 4-year statute of limitations applied. So in a sample case, an owner or their attorney would file lease documents going back 4 years, and in some cases you may say, okay, here's our lease documents, there's no rent overcharge. Or you might say, here's our lease documents, we see that there is some overcharge in reviewing this, and we are now giving the tenant a refund and reducing the rent, so there's no further problem with this. So now that those complaints have sat all this time, DHCR has now started sending out, within 2 weeks after the law changed, DHCR on the pending overcharge complaints is sending out notices saying, in connection with this proceeding, the law has now been changed, there's now a 6-year period to look back, send us documentation going back between the 4 and the 6 years. And in some instances, that may not change the result. In some instances, it may change whether there is an overcharge, depending on what's happened, between 4 and 6 years ago. And it may also now involve further delay of making a decision because the DHCR has to give the owner some time to respond to this. And one of the things owners may want to do who are responding to these complaints is it probably is prudent to provide the information if you have it. Otherwise, DHCR will make a decision based on a default method. But what owners may also want to do is make objection to the change in the procedure. Even though the law specifically said it's applying to pending proceedings, changing the rules at this point in the game, after people have answered complaints a long time ago, can create liability that wasn't there otherwise. So is that fair? Is that a violation of due process? Is that a taking of property, either physically or in a regulatory manner that violates the Constitution? Those types of objections should be raised. Where they will go remains to be seen, but in order to preserve the right to appeal if there's a bad result, it would be helpful for owners to make those objections.
There has been a lawsuit filed against the challenging the constitutionality of the new law by owner groups.
There is. In July, I think it was by mid-July, CHIP and RSA and about 6 or 7 named owners filed a lawsuit in federal court against the City of New York, the Rent Guidelines Board, and the Commissioner of DHCR. And the claims are primarily that the rent stabilization laws, including the amendments to the laws, violate the Constitution by denying due process and by taking property, taking property for public use without just compensation to the owners. That's the Fifth Amendment. So it's in the early stages. I'm sure there's been no answer filed to the complaint yet, and people may have questions about what the lawsuit's all about and procedurally what it's about. One thing, I am not a constitutional scholar by any means, but I know that the case was brought against the city and the Rent Guidelines Board and the DHCR Commissioner as enforcers of the law. They didn't sue the state of New York or the legislature. And one reason for that may be that I don't think you can bring a lawsuit against the state about constitutional stuff. But what you can do is bring it against these other entities in federal court, rather than bring the matter in state court. The other thing, there has been, right around the time that the rent stabilization law was amended, about a week later, the U.S. Supreme Court issued a new decision concerning the taking of property rights, and they reversed some prior opinions of the Supreme Court from about 30 years ago. So there may be more room for the owner groups to pursue the takings claim under federal law as it exists right now under the latest Supreme Court ruling.
Okay, let's talk about individual apartment improvement rent increases. What has changed about getting IAI increases now?
This is something that has changed a lot also. For some time under rent stabilization, owners were allowed to collect increases for making individual apartment improvements, generally done during a vacancy. If individual apartment improvements were done while a tenant was in occupancy, you could collect a rent increase for that only if the tenant agreed to it in writing. And that is still the case, and there probably will be some kind of form issued by DHCR for this purpose. There is already a DHCR form for rent control tenants for this, but there now will be one for rent stabilized. But if you make an individual apartment improvement while an apartment is vacant, you don't need tenant approval for that. Previously, there was no limitation on how much money could be spent, and you were entitled to collect 1/40th of the cost or 1/60th of the cost of the improvement. That became the monthly rent increase. It was 1/40th if you had less than 35 apartments in the building, and 1/60th if it was more than that. What has now happened is that the law says that owners can only collect $15,000 in IAI rent increases over a 15-year period. They made it the aggregate. So that means you might do IAIs costing $15,000 once in 15 years. You might do $5,000 this year, $5,000 5 years from now, and another $5,000 down the line. But you can't collect more than $15,000. And instead of 1/40th or 1/60th, the increase is now 1/168th if it's less than 35 units, or 1/180th if it's a larger building. So it's a pretty small number that you end up being able to collect for IAI increases. And IAI increases generally applied to, it could be minor things like changing the kitchen or bathroom appliances. Sometimes it involved a gut renovation of an apartment that may have been occupied by the prior tenant for 30 or 40 years without being upgraded. So it's a big difference in what owners are entitled to as rent increases. The other thing is that these IAI increases are now temporary instead of permanent. Previously, if you had an IAI increase, say you spent $50,000 on a gut renovation of an apartment, you got an IAI increase, I can't do the math in my head that fast, of whatever you got, 1/40th of that became what you added to the base rent for the new tenant, on top of your vacancy increase. Now it's a much smaller number, and it does not become a permanent rent increase. It's now a temporary rent increase that is supposed to come off the rent 30 years from now. How that will all be set up and done, I don't know. Since it's become a temporary increase, one question is, does it become part of the base rent for calculating the next rent increase, or can you not do that because it's a temporary increase? And then how do you structure that, and how do you calculate it, and how do you keep track of all that? That's something that DHCR should certainly be issuing some guidance on.
Some forms,
fact sheets, whatever they do. The DHCR rider that's supposed to be given to all rent-stabilized tenants with vacancy or renewal leases has on, I think it starts on the second page. There's a whole page or page and a half of calculation lines. They'll have items that show item by item how the rent is increased from the last rent to the next rent. So those forms are going to have to be redone. I don't know how soon that will happen. So that and this is something a lot of owners have expressed concern and questions about, and I think some construction industry people have expressed some concerns about, because it will probably have a significant impact on how and how much IAI increases are done.
Yes, well, now let's talk about MCI rent increases. How does the law affect that?
Okay. MCI increases have now also become temporary rent increases instead of permanent rent increases. And MCI increases have also now become subject to longer amortization periods. I believe that depending on the size of the building, the MCI increases were granted in a way before the law changed that the cost was recovered over 8 or 9 years, but it continued as a permanent rent increases. Now the costs are recovered over 12 or 12 and a half years. And again, like the IAIs, the increase is temporary, again, on this 30-year time limit. And how that all gets placed or not into the base rent remains to be seen. What is also changed on the MCIs, there has long been a cap on the collection of MCI increases. When you file an MCI application, you include a list of the tenants and how much rent they're paying at the time of the application. The MCI increase is a per room increase. So say you get $5 a room, it's a 2-room apartment, the person's getting a $10 a month rent increase. If that $10 results in an annual rent increase that's more than 6% of what the tenant's rent was when you filed the application, you couldn't collect more than 6% the first year, and then you could collect the rest of it, after that. Now that 6% cap has been reduced to a 2% cap, starting with leases that come into effect, I believe, in September of 2019, but it relates back to MCI increases granted back to about 2013 or 2012. I forget the exact date. So this is going to involve a lot of recalculation on the part of owners or managers who have to figure out how much is the lawful MCI increases that get added to leases. The other thing that has changed about MCI increases is that there's no longer any retroactive increase. There was never a retroactive increase allowed for rent control tenants, but if you filed an MCI application a year and a half ago and then it's granted by DHCR, the increase would be made retroactive to the point where tenants got notice of the MCI application. The other thing you'd have to figure out is, are you collecting the prospective increase first or the retroactive, and how does the 6% cap work with that? But the simplification now is that there's no retroactive rent increase. I think I have seen 1 or 2 DHCR notices come out on pending MCI applications right now that mention what some of the changes are to the law in connection with MCIs, but I haven't seen how it's technically affecting things so far. But there are a lot of questions about the calculations and what to do with them.
Okay, well, let's talk a little bit about how the law affects rent control departments. When do changes to maximum base rent and fuel cost adjustment increases take effect? And how will that work?
How it will affect the current cycle of MBR applications, I am not exactly sure, except that I think since the changes are effective as of June 14th, it will affect the current cycle. Rent control increases have always been more structured than rent stabilized increases, and you can only increase rent control tenants' rents by filing an application with DHCR for approval, showing that you didn't have too many or any violations on the building or apartment, and you'd get approval to increase what they call the maximum collectible rent, and generally that was 7.5% a year. Now the law has been changed so that what can be collected when you get approval to collect an MCI rent increase is you'll get approval to collect either 7.5% or the average of what the last 5 rent stabilized guideline increases were, whichever of those numbers is lower. So it's, it'll involve math, it'll involve, different results in different cases. The other thing, just to point out about rent control apartments, I did not mention this when we were talking about rent overcharge. The change in the 4-year rule to the 6-year rule does not apply to rent control because there are a lot less overcharge complaints concerning rent control to begin with, since the rents are more structured. But the rules have always been different, and with rent controlled apartments, the statute of limit, you only went back 2 years instead of 4 years. And DHCR would not issue orders for rent control tenants saying, okay, we found an overcharge, you have to pay back the overcharge and treble damages. What they will do with rent control tenants is say, we found an overcharge, or we found that the rent should be, this amount, not what you're charging, and if the tenant wants to pursue this, they have to go to court and get a judgment. And I just mentioned treble damages, which reminds me, one thing I did not talk about when we were talking about rent overcharge is that the treble damage provision has been changed also. It used to be that if you filed a rent overcharge complaint today and there was an overcharge, the DHCR could direct the owner to refund treble damages, 3 times the amount of the overcharge, going back 2 years, or going forward if you were still collecting it, even if you had to go back 4 years on the total overcharge. That part of it would only be subject to interest. Now, if a rent overcharge complaint is filed and you go back 6 years, if there is an overcharge going back 6 years, the owner will be hit with treble damages for the 6 years.
Wow.
And also, what was a long-standing procedure, that if you answered an overcharge complaint and within the time you had to answer, you discovered an overcharge, you stopped overcharging, you corrected the overcharge, you would not get hit with treble damages for that. What they would call the safe harbor. The safe harbor has been removed. There is no safe harbor protection against overcharges and treble damages on overcharge. Treble damages are for willful rent overcharge. So proving that an overcharge is not willful, the burden of proof is on the owner, and it's very difficult, or has been very difficult, to overcome that in the past.
Thank you, Eileen, for joining us today, and thank you all for watching. To keep abreast of the continuing developments on the rent laws, find out more information, please go to apartmentlawinsider.com and look forward to the next edition of the Rent Regulation Checklist, which will contain all the changes. Thank you very much for watching.